Hello, welcome to This Family Does Everything. My name is Alexandria, and while I know it's been a while, let's finish up this trial. So let's sit back, watch, and analyze the Darrell Brooks trial.
I don't have any other questions.
No redirect.
Thank you, ma'am. You may step down. You may call your next witness, please.
So we're gonna take down these exhibitors. You're gonna stay up
Oh,
on there.
thank you. We'll take it down. Please call your next witness.
Just 1 second. So you one more person here, right?
It's my understanding, sir. Would that be correct, Attorney
Yes.
Upper?
Yes, she's in the courtroom ready to go, Your Honor.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Babiasz.
I believe it's Babias. What's your last name? Babias. All right. Thank you. You are at the witness stand. Would you please raise your right hand? My clerk, Teresa, will swear you in. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Catrice Babias, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Babias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn? Was it gesturing to people?
Yes.
And What do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustain us to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Let me back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
The driver looked like through me.
What do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look, but it was very frightening.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle...
Hold on, I just need to make a record of she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with law enforcement about what you saw that evening. Would that be fair to say?
Yes.
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Do you recall, well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle?
Yes.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't, to be fair, you said you didn't know. You said it was that week is what you said. The same week. You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh. but you didn't report this at any time whatsoever.
That's the answer to the question.
Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
So today, your first time bringing up your alleged injury?
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena?
Correct. The instructions told me to.
Okay. You ever spoke with anyone directly at the district attorney's office?
No. Correction. Yes, when I walked in today, I met there and let them know I was here, and then they walked me into a room, and I waited until I was called by you.
So before today, you had no interactions with anyone related to the district attorney's office besides the, I think you said, victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
And I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
Have you ever testified in any way before today?
Objection all this.
Grounds.
Overruled. She may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
I want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was
question
a,
was when it was approaching.
I'm confused.
Hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep. So I saw that an officer have to get out of the way, and he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor. If I
Your Honor,
may
I just
have.
want to object to this line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
But there is now.
I'm going to sustain the objection under 906.11, because I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead. But I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained. You don't have to answer that. I sustained the objection on those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustained. That
Not
was
relevant.
What? Mind-boggling. Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection. Relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness. It's
The
your
subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906.11, please ask the witness a
This is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
that's- I think
I'm
that's very
sustaining the
relevant.
objection under 906.11, and I'm asking you to move on.
Y'all, this ridiculous, man. Seems to me like a like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 906.11, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 906.11, please ask a question, sir.
Man, what is y'all people trying to pull, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 906.11, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 906.11, you are directed to ask a question, or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you.
Thank you. Next question, please.
Know who the plaintiff is in this matter?
Yes.
Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm going to get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overruled, the witness may answer.
Of course it's going to be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that,
Overruled,
it was
the witness may
it was
answer.
sustained?
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
Okay. I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show...
Wait until it's in the jury
I'm
box.
sorry.
I'm sorry. The jury would let me know when it's there.
Ma'am, do you see a purple line that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Objection, asked and answered.
Overruled, the witness may answer.
There were barricades that were partially blocked. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Okay.
Overruled,
Hearsay.
the witness may answer. It's not hearsay.
So when the red
Yeah,
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you've testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
Yes, hearsay. She's speaking as a
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's always overruled.
Go ahead, you may answer, ma'am.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes.
Okay, yes.
Okay, thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's
And
mischaracterization of what was testified to.
Overruled, the witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection is speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one would have been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
Okay. And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Objection. Speculation.
Overruled. The witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Dri-
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Let me read your record.
Yep. You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that you, the interview that was conducted with the FBI, that was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why that wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. Would that be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding
That's
her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't-
ask
you really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form.
But you said
Mr. Brooks, I made my ruling under 90611.
You said
Please ask
intimidate.
a question or
I'm trying
I will
to merely,
stop the
How did
questioning.
I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62 trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Yourself a judge as much as bias you could put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state that
know that.
she could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to
We
have her
said-
here
we
at 9
We said all
a.m.
that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to
things.
make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so what
down
do it
for
matter? You
the
can
better
hold me
part
in
of 2
contempt
hours.
all you want. You can hold me in contempt all you want.
I'm not
All
holding
gotta
you in
do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna
make-
give you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the
Mr.
next
Ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
To reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those, and once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness, who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word, it's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, or relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is, and then based upon his decision, I of course will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, consent or lack of consent or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence, State versus Robinson. 146 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 906.11. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So, just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks, and I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes. Sure. With the hope of and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font, so with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now?
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She never wrote one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised. Sir, anything you wish to address before we break for the day?
Yeah, I can. I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them. That has yet to be done. I've put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is
in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1. Then you sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seem to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment right. You violate my First Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment. You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, 1, that I wasn't prepared, 2, that I did not understand the proceedings. But yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction, for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you knew, when you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess. Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning to you as well. The record to reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I just went to you and then went to the prosecution. Is the audio on?
It is. The audio's on. Do you know when you sent those?
Saturday. So that would have been the 22nd.
State receive anything through like the interoffice communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection.
From you, sir?
No objection. definitely want those documents received as they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state, if any?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a mood issue.
I don't believe it's a mood issue. And I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm gonna turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness. Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
trust...
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
from the state
addressed,
that we
Your
provided
Honor.
for the state. Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to...
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and
seem
I'd
like
ask that you
you're.
stop
I
interrupting
don't need your
me.
advice.
No, I have to
need
give you
you-
advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will be
you're holding me in
removed
contempt
to the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You are
I'm merely
advised
trying
that
to
a
understand
continued
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've
forfeiting
said that
my
multiple
right.
times.
You
I've
saying-
given you multiple opportunities
You're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
standards
because
of
it
form and
doesn't.
civility, and
Illinois
one of the
doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being interrupted.
It does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It
Again, I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
And video are working in the neighboring courtroom. All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute, though, and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse, to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Yes. This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court, because that only mutes your audio coming into this courtroom. I confirmed already
Why
that
is my audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now?
What she talking about?
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time. For the record, he's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. Just speak directly to you. I'm trying to hear. Can you hear?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying, so cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear, and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants, he takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear his statements that when I mute his audio, that it mutes his audio are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you made a decision to tell me?
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or don't?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted?
Sir, do you want to testify in this case?
You was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do you want to?
Nothing, because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to testify? All right, I'm going to answer. I'm going to mute him again. Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum, again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
Questions for, I didn't hear you ask me anything. And
sir,
I don't understand.
Stop talking and I'll ask it again. Sir,
can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
I can hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir, you
asked me a question now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Are you willing to...
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out. Get this back.
All right.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll give them back to you during deliberation. Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.